All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Morning, counsel. Let me call the case. This is case CV150516. And counsel for the appellant, how's your client's name pronounced? Equiani. Henry Equiani et al. Versus Matheson and Matheson et al. This is the time set for oral argument. Counsel, as you know, you both have 20 minutes to present your case. Counsel for the appellant, Mr. Equiani, you can reserve some time for rebuttal. Just let us know when you get up. There's a clock for you to keep track of your time on the podium. We've read everything in the case. We're familiar with the issues, so keep that in mind. I do want all counsel to know that these proceedings, this argument, is being recorded. So there's going to be an audio recording and a video recording that's uploaded to our website. I want you to be aware of that fact. It'll probably be uploaded maybe in 2 or 3 days. With that being said, it is Mr. Don't tell me. Entrican?
Yes.
All right. Did I pronounce that right?
You did, Your Honor.
All right. Your argument?
Thank you. May it please the Court, Lance Entrican for plaintiff's appellants. I would like to respectfully reserve 4 minutes of my time for rebuttal. I am aware that the Court is very familiar with the record, and so I won't go through it, but there is one point that I wanted to hit briefly, and that is in the underlying record. The minute entry said the basis of our claim of malpractice was that counsel in the underlying case had not included substantial amounts of material in response to a motion for summary judgment. That is part of the basis of our claim. The other part of the basis of our claim, which was not mentioned, was that counsel in the underlying case admitted Statement of Facts 101, which was demonstrably false. This arose from not being familiar with the email referenced in that Statement of Facts, and that became the basis, or one of the bases, for Judge Martone's decision. So it wasn't just leaving out evidence, it was also admitting something that should not have been admitted. With that said, I just wanted to hit 2 points briefly. The first point is that for many years now, at least 50, going back to Martin v. Burns that I can see, this court has published cases wherein this court has upheld a legal malpractice expert testifying if lawyer X had met the standard of care, then Judge Y would have ruled differently and not dismissed the case. And in fact, this court, and I cited 5 of these cases in my brief, but I wanted to look at 2 briefly before I touch on Timonard. In Hyatt Regency versus Winston and Strawn, 184 Arizona 120, at page 131, this court said an expert test, basically what happened was Mr. Greenfield messed up a case. He didn't disclose a conflict of interest, and the allegation was he left one client out in the cold and protected the other client during the hearing. Winston and Strawn said, we only hired him late in the game. We had nothing to do with this. All of this was done when he was at Snell and Wilmer. This court said that the expert for the construction subcontractor that he represented, along with the main contractor, the expert testified, quote, and this is at page 131 of that decision. The expert testified, quote, Winston and Strawn should have moved the special master to reopen the evidence to allow HRP to advance its defense and cross claims. This court went on to say that that was proper expert testimony, and that was a basis for a finding of liability, a breach and causation against Winston and Strawn. So this court said it is appropriate for an expert to testify, hey, Mr. Greenfield had all of this evidence in his possession and he didn't offer it, and that caused HRP to lose, and he should have offered it. If he had offered it, the tribunal would have ruled differently. This court found that to be proper expert testimony in 1995. In 2012, the Arizona District Court in Kaufman v. Jesser, 884 F sub 2nd 943, at page 948, you had a guy who was just obsessed with his parrot, who was named Salty. And Salty died, and he sued the veterinarian. And he hired a guy off the internet who said, I'm the guy who sues veterinarians, and he was out of Illinois. He subsequently lost, and his theory of legal malpractice was that the attorney out of Illinois had a ton of evidence in his possession that he had given him that would have shown this veterinarian had malpracticed in regards to Salty, and he didn't offer this evidence. And he argued, Kaufman argued in the underlying case, that he didn't have to use an expert witness. And the Arizona District Court said, under Arizona law, you are required to use an expert, and that expert will need to testify that Mr. Jesser violated the standard of care by not using this evidence, and that failure to use this evidence caused you, Mr. Kaufman, to lose your case against the veterinarian. So again, the Arizona District Court said it is appropriate for an expert witness to testify. In my opinion, lawyer X had this information they should have used. They didn't offer it. And in my opinion, that caused Judge Y to dismiss the case. That was an appropriate topic of expert testimony in Kaufman v. Jesser and in Hyatt Regency v. Winston and Strawn.
And so you have that testimony here in the form of a 2602 affidavit. Is it your contention that any time you have that testimony, summary judgment is impossible?
It is not.
Okay.
And the exceptions I would draw would be if the expert repudiates that testimony in a subsequent deposition, which he did not in this case. If the expert is not qualified to offer that testimony, you bring in a commercial expert and it's a tort case or something. If the expert is not properly foundationed, or if in rare cases, if the court just concludes that the testimony is ludicrous on its face. In this case, the testimony was not ludicrous on its face. We showed the trial judge 900 pages of material that Justice Slackett had gone through in great detail and referenced in his affidavit in great detail. Justice Slackett is qualified to offer, I don't think that's under dispute. And in his deposition testimony, he backed it up.
I'm kind of laughing because the way you phrased it, ludicrous on its face. I know what you're trying to say, but I suppose there could be an affidavit that just the expert's qualified, but it's just insufficient. What he has to say is not enough to show that there was a breach of the standard of care, right? That could happen.
I mean, I would go a little further than that, and I would say an expert who is qualified and has proper foundation and backs it up in deposition and is timely disclosed, addresses causation, but just makes a statement that is just ridiculous and beyond the bounds. And ultimately the court says, yeah, this guy may be, or this gal may be qualified, but I just can't accept that as being something within the realm of reasonableness. I mean, I always try to leave that out for any judge, I think. But it is my contention that if, as in this case, you have a qualified expert, timely offers the affidavit, addresses the causation issue as required by statute, backs it up in deposition, proper foundation, the court is not free, as the court did here, to just lightly disregard that and say, well, this is a pure issue of law and the special province of the court. Because it's never been treated that way, ever, until this case. And the other example I was going to cite was, of course, Timonard. I mean, in Timonard, the language is, very hard to get around. Quote, page 318 of Timonard, quote, the deposition testimony of Reed's expert was stronger than mere speculation. He testified that he believed the proposed decree would have been signed. The defendants did not present any evidence rebutting Barker's testimony on this issue. This court is saying they should have rebutted if they wanted to dispute it. The jury, as the trier of fact, has the duty to determine what a reasonable judge would have done. Again, I would like to repeat that. The jury, as the trier of fact, has the duty to determine what a reasonable judge would have done. That is this court's holding. In addition, although the defendants chide Reed for not presenting evidence that Dr. Reed's attorney would not have objected to the proposed decree, they have not presented any evidence that the attorney would have objected. Even if such evidence had been presented, the jury could still find that the judge would have entered the decree over such objection. The trial judge knew that Timonard was an insurmountable obstacle for him, and so he tried to distinguish it. And he said, well, yes, both Moliver and Timonard do deal with legal issues, but Timonard is quasi-factual in nature, and therefore it's different than this. It's not at all. In Timonard, you have a statutory standard, 25-318B, that says if you want to get property in a marital dissolution, you need to account for the debts that the couple has. And the way you count for those debts is you do this and you follow this legal standard. Reed came in, an expert, and said, in my opinion, Mr. Timonard did not meet the standards set forth in 25-318B. And had Mr. Timonard met the legal standards set forth in the statute, Mrs. Reed would have gotten more property. That's no more quasi-factual than this case. In this case, Justice Slackett is saying exactly the same thing, and he's saying the same thing that was said in Hyatt Regency v. Strawn and in Kaufman v. Jesser and in a dozen other cases over the last 50 years. He's saying a dozen published cases, probably 100, well, I don't know about 100, but 30 or 40 non-published. He's saying, in my opinion, had Ms. Matheson met the legal standards set forth in Orem School, had she offered this evidence in her possession, as Mr. Greenfield should have in Hyatt Regency, as Mr. Jesser should have in Kaufman v. Jesser, as Mr. Timonard should have in Timonard, the judge would have ruled differently. All of a sudden, we're told that this is a pure issue of law, and the court is free to disregard this. And what's particularly problematic about that statement is that, and I'm sure the court is familiar with this, but I just briefly touch upon it, they had already thrown the Equianes, who were pro se at the time. I had not come into the case. They had thrown the Equianes out of court on the theory that, well, yes, Justice Slackett did testify the standard of care was violated, but he didn't touch upon causation, and the statute requires him to, so he's out of court. Summary judgment granted. So they go and they get a supplemental affidavit from Justice Slackett saying, well, I should have clarified. Yes, I think the standard was violated, and I believe that violation caused this case to be thrown out of court. And they've already got an expert teed up, Mr. Katz, who's going to rebut that. They suddenly push him to the side, and they say, wait a minute, Your Honor, just ignore Justice Slackett's causation testimony, even though he's qualified on proper foundation, even though we stipulate this does in fact address causation, even though he later backs it up in his deposition. Just ignore it, because this is a pure issue of law that you decide. And the judge does. So they're thrown out of court for not having Justice Slackett testify on causation, and then when he does, they're told it's irrelevant, and they're thrown out of court again. And the problem with telling them that it's irrelevant is contained in the statute which we're all familiar with, which is 12-2602. This was passed in 1999, 12 years after the Molliver case. And I'm not going to spend any time on the Molliver case. The only basis for their entire argument is one line of dicta in the Molliver case. And why is it dicta? Because the Molliver case was not addressing expert testimony. There's no expert testimony at issue in Molliver. Go through the opinion. They don't say, well, this expert testified to this, but we choose to disregard it because it's a special province of the... There's no expert testimony at issue in Molliver. There is in this case. That's why Timonard is on point, and that's why their one line of dicta from Molliver is irrelevant. But even if the court meant that at the time in the way they say they meant that, that was 87. In 1999, the Arizona State Legislature passes a law, 12-2602, and says, quote, basically, let me back up just a moment. The legislature says to people like me, hey, plaintiff's legal malpractice lawyer, you are out of court on pain of dismissal unless by a certain time you offer an affidavit which says, quote, where your expert testifies upon, quote, the manner in which the licensed professional's acts, errors, or omissions caused or contributed to the damages or other relief sought by the claimant, end quotation. Okay? On pain of dismissal, I have to get an affidavit that describes the manner in which the licensed professional's acts, errors, or omissions caused or contributed to the damages. And if I don't provide that affidavit timely, I'm out of court, as happened to the Equianes pro se in this case. They are now saying that is a pure issue of law in the sole province of the court. First of all, as I've shown in these cases and others that have been cited to the court, but I'm not discussing here today, that has never been treated as a pure issue of law.
What is that?
That being an expert witness in a legal malpractice case testifying, in my opinion, if lawyer X, defendant lawyer X, had offered this evidence that he or she had in their possession, the judge would not have dismissed the case.
The adequacy of that 2602 affidavit, though, would be an issue of law, yes?
The adequacy of the 2602 affidavit, yes.
Okay.
Yes, it would be, absolutely. And, you know, if, for instance, somebody offered a 122602 affidavit and it didn't really address causation, but they said, hey, I address causation, ultimately that's for the court to decide. In this case, that is not before the court, because while they didn't stipulate as to the merits of the affidavit or say that it was they agreed with it or anything else, they did stipulate that he had in fact addressed causation. But then they turned around and said, well, sure, he's addressed causation, but who cares? This is a pure issue of law. This has never, ever been treated as a pure issue of law. You have a dozen published cases that address this exact issue, like Kaufman and Hyatt Regency and Tim Menard, and it's very clear it's not a pure issue of law. But you are absolutely correct that the adequacy of the affidavit, if there's some dispute as to when it was disclosed or whether it addresses causation or whatever, that is certainly for the judge. But anyway, I would just close, since I'm coming up on my 4 minutes reserved, I would just close by saying it makes absolutely no sense, and it is irreconcilable, that the Arizona State Legislature would throw me out of court on pain of dismissal for not timely offering expert testimony on causation if that expert testimony is a pure issue of law and the sole province of the court, and the court is free to ignore that testimony, because the Arizona State Legislature would, I hope, not require me on pain of dismissal to offer sworn expert testimony on a pure issue of law. And with that, I will close.
One could argue that such testimony should never be admitted, but go ahead.
Thank you, Your Honor.
All right, thank you, counsel. Is it Ms. Orz?
Orzi.
Orzi.
Thank you, Your Honors. Your Honors, it befuddles me that in the practice of legal malpractice cases for many, many years, I have never seen anyone argue, and I can't say that anymore after today, I've never seen anyone argue that juries would decide whether a case is susceptible to summary judgment. A judge decides whether there's a material issue of fact that goes to a jury on a motion for summary judgment. It's a legal question for the court to decide. A jury doesn't get to overturn that judge. A jury doesn't get to second guess, and if the judge says there's a factual issue, then it goes to the jury. Moliver has been the law in the state of Arizona for many, many years. It has not been overruled, criticized, or in any way denigrated by Reed or by any other cases that we're aware of, nor has it been modified by the passing of the legislature of 122602.
Does this really matter? If we determine that there was a possibility of generating a dispute of fact, had all the evidence been submitted, had the admission not been made, then it doesn't really matter whether a jury decides it or the court, right? Because we can decide that question as a matter of law today.
You can decide it as a matter of law today, and Judge Gordon at the trial court level was to decide it as a matter of law there. So you're right in that it doesn't matter. What matters is what's in the record. What was in the record before Judge Gordon, and what is in the record before you to review now. And
our review of Judge Gordon's determination is de novo.
Yes, it is. Okay. It is. And so while the plaintiff has argued strenuously that Judge Zlackett, former Judge Zlackett, Tom Zlackett's affidavit was sufficient to create a fact issue because he said there was one, that's really for this court to decide, and it was for Judge Gordon to decide, and it's not for Tom Zlackett to decide.
Well, but and I'm sympathetic to the notion that courts don't really need experts telling them what the law is. I go so far as to say that's probably improper. But 122602 does require an expert affidavit in a case like this. And isn't it a foundational fact for such an affidavit that there actually was a chance for plaintiff in the underlying case? It may not be the ultimate conclusion of the expert affidavit, but he has to say it.
The expert
or else
does-
there would be nothing to testify about.
That's correct. The 122602 does require that the expert say, here's the standard of care, it was violated in these respects, and that caused some form of damage.
So if he didn't say, I think the trial court in the underlying case would have denied summary judgment, he couldn't really ever testify about causation, right?
Well, if he didn't say that there was some damage caused by the malpractice, there wouldn't be malpractice. The plaintiff wouldn't have established a prima facie case, and precisely what would have happened to that plaintiff is what happened here.
So even if you're right that that the question whether the district court would have granted summary judgment is a question of law for the court, it's still an appropriate topic of discussion in a 2602 affidavit.
I don't disagree at all.
Okay.
It's an appropriate topic of discussion in a 122602 affidavit. However, when the issue before the trial court, as it was in this case and as it was in Molliver, was whether or not there was in the record before the court at that time sufficient evidence to create a factual issue that would allow this jury to see this evidence and make a determination that there was race-based discrimination instead of what Ameriprise said it was. When the issue is before the trial court, the legal issue of whether there is a material dispute of fact in the record sufficient to go, that is a legal question, and the trial court does not need the opinion of Tom Zlackett or our Larry Katz or any other expert to make that determination. That determination is solely for the trial court. And that's what Molliver said. When in a legal malpractice, when a legal malpractice case, the alleged negligence results in or is bearings on a legal issue, a question of law for the court, then whether there was causation for the damages is a legal question for the court.
Okay, so should we get to that legal question?
Well, the legal question is, in essence, yes. I would argue, and I argue today, and we argued it in our brief, the plaintiff has not come to you and said there was sufficient material dispute of fact on causation in the record, and Judge Gordon was wrong, the trial court was wrong. The plaintiff is hanging his hat exclusively on this issue that because there's an affidavit from Tom Zlackett with which Judge Gordon disagreed, that this court should, as Judge Gordon should have, just accepted Tom Zlackett's opinion and let that substitute for the determination.
Well, okay, let's say we go right past Zlackett's opinion and just look at the underlying material about which he testified and consider the legal significance of it. Would we reasonably expect that a trial judge would grant summary judgment had he been aware of the facts as plaintiff suggests they are?
Absolutely. Judge Gordon, first of all, it's not clear, as the plaintiff makes it out to be, that Judge Gordon ignored or somehow wrote off or lightly disregarded Tom Zlackett's affidavit. It was in the record. He didn't say, I'm ignoring it. He's saying this is purely an issue of law, and I find, as a matter of law, that there is not sufficient factual dispute. There's not sufficient evidence in the record before me that Mr. Ekwani was the victim of race-based discrimination. He has not met his burden of putting that evidence into this record. That's what we asked Judge Gordon to do, is to look at the record that was before the district court and to look at the record that was before him now. Now, if the plaintiff the plaintiff said in their opening brief and they said in their motion for summary judgment that that the Mathesons had overwhelming abundance, compelling evidence that this was race-based discrimination. It's not in the record. And to the extent that they allege that my clients should have produced that record or produced that evidence for the district court, they needed to produce it for the trial court in this case, because this was a motion for summary judgment where it's time to show your cards, and it was up to the plaintiff to put into evidence what they say Tom Slackett relied upon.
That's exactly the concern, though, isn't it?
The concern is, for me, the concern is they failed to do that, and the trial court saw that they failed to do that. Because what we have is Tom Slackett's testimony saying, I don't know what Wenning Mao would have said had they deposed her or him, because no one did. And where they're arguing that there was compelling evidence of race-based bias, they've not put it into the record.
Well, I mean, it's one of those cases of be careful what you wish for, though, isn't it? Because you said this is the time to show your cards. I think that's the argument in the underlying case, is that the cards, we now know what the cards were and how they existed at the time, but not all of them were shown, and that's the problem.
Well, the problem here now is that the plaintiff is still not shown cards that are sufficient enough from which a jury could find race-based discrimination instead of that Mr. Aquani was terminated for cause.
Okay. What element of a race-based discrimination case could Mr. Aquani not have shown based upon the evidence as it could have existed had all the cards been shown?
There's no evidence in the record whatsoever. There's no direct evidence that his employer made any racial epithets, any slurs, any discrimination.
You qualify that with the word direct. Direct evidence is not required.
I'm going to move on, okay? Because in the employment case, the context before the district court was that once the burden-shifting paradigm of the McDonnell-Douglas case came into play, Ameriprise, the employer, said, we have a legitimate reason for all of our employment actions. Here's what it is. They documented it with actions that were taken against Mr. Aquani prior to his having engaged in any protected activity, well documented in the file. And once they did that, then the burden shifted to the plaintiffs to demonstrate that that was pretextual. And by pretextual, not that it was wrong, but that it was dishonest, okay? And there's no evidence that it was dishonest. There's no evidence that he was subject to adverse employment action because he was a minority. No evidence at all. So they could come forward with circumstantial evidence, and if they do that, according to the federal law on the issue, the circumstantial evidence has to be direct and it has to be specific. I'm sorry, not direct. It has to be specific and substantial. And the Mathesons did the best they could in coming forward with that. And what they put forward, the district court found wasn't enough. Now, if there was more that the plaintiff now says that the defendants should have done and put into the record, it was incumbent upon them to put it in the trial court in this case below, and they didn't do so. In other words, let me be real specific about something. For example, the claim is that Cornell Ray was another black employee who was terminated from Ameriprise. And Tom Slackett says, well, if they had hunted Mr. Ray down, they could have gotten testimony from him that said this and this and this. He admits that he doesn't know what Cornell Ray would have said. There's no evidence in the record of what Cornell Ray would have said because it's now incumbent upon the plaintiffs, if they're going to prove up that Cornell Ray was subject to some kind of Me Too discriminatory motivation, it's incumbent upon him to put that evidence in the record here. The plaintiff didn't do that. They relied upon the additional evidence that they asked my clients to put into the record in the motion for reconsideration at the district court level. They put in everything that my clients put in everything that the plaintiffs wanted them to put in at the district court level. Everything additional that they had, Judge Martone had it. He rejected it. He said, there's nothing here that you've put in that gives us pause with respect to whether or not there was evidence sufficient to get to a jury that Mr. Aquani was subject to race discrimination instead of being terminated for his own conduct.
What do you make of Judge Martone's comments regarding the prospect of reconsideration?
You mean the comments of you don't swing after the bell has rung?
Yeah, I'm not asking for a critique of his use of
Okay.
language, but more the notion, is there an inference to be drawn there that had they swung before the bell was rung, it might have made a difference?
It doesn't matter. And the reason it doesn't matter is because Judge Gordon, in this case, had all of the evidence before him that the plaintiff wanted into the record. The plaintiff had an opportunity here to take a second swing, to put everything in that they claim my client should have put in, and they didn't put in anything additional than what was put in the first place, and it wasn't enough. And the reason it wasn't enough is because it wasn't there.
So based on the record we have, it sounds like the real core of your argument is that it is undisputed as a matter of law that they had race-neutral reasons for making the decision they made, and no other ruling except summary judgment could obtain. There's not one shred of evidence, and let me take back shred because we're not a scintilla state, but there's not one piece of evidence sufficient to generate a dispute of fact on that issue.
Correct. There is insufficient evidence of race-based discrimination or what pretext is and what they have to prove with evidence, and not with an opinion that they should have put evidence in to prove it, but with evidence that the offered explanation for Mr. Aquani's termination was not just false, but that it was dishonest. It's not enough that Mr. Aquani disagreed with his employer when his employer said your communication skills need work. You need to improve your reception to criticism. You need to work better with your supervisors. You can't denigrate them. You can't mock them. There was evidence that Ameriprise put into the record of things that he had done, that he admitted to doing, and that he acknowledges before he engaged in any protected activity whatsoever. And the record showed, in the record that was before Judge Gordon and that was before Judge Martone, was that once Mr. Aquani wasn't promoted to the position that his coworker was promoted to, before he had gotten along with that coworker just fine. Once he wasn't promoted, that relationship deteriorated. He mocked him. He said that his leaders had no qualifications, that they didn't know enough. When he was criticized by business partners, he said it's their fault that they don't understand, they're just not smart enough. And he blamed them. And then when he got a performance review, instead of saying, I need to make some changes, I need to be receptive to leadership and to the needs of the business partners in this practice, instead of working on that, he submitted a 44-page rebuttal, and it's in the record, a 44-page rebuttal that says, you are wrong. You are completely wrong. My evaluation of myself is perfect. I've not done anything wrong. And he was terminated. Precisely the reason that they articulated was that he was unable to receive leadership and to take criticism and to improve. And there was no evidence that they falsified any documents, that there was any racial-based, unlawful reason for his termination. And what pretext is, what the plaintiff's burden was to prove in the underlying and to put enough evidence into the record before Judge Gordon so that a jury on this record could determine from evidence reasonably that he was terminated because he is black and not because of his own conduct, that he was terminated because of illegal conduct by the company.
These cases often get so factually messy, but I think you'd agree that one who thinks he's doing a good job can't be fired simply because he doesn't take criticism. There's an inherent tension there, right? It's logically impossible to ever make out one of these cases if you defend yourself.
Well, people make out these cases all the time, and they defend themselves.
And that's why I'm saying, if the basic logic of your argument holds true in all cases, people wouldn't be able to make out these cases all the time. I mean, it seems to me that it's a very fact-specific inquiry.
It's a fact-specific inquiry, and the federal law recognizes that, and that's why they have the burden-shifting paradigm of the McDonnell-Douglas case, that allows for the burden to go to the employer to proffer a legitimate reason for the action, and then the burden shifts to the plaintiff, and it remains with the plaintiff.
But the McDonnell-Douglas scheme is a scheme for trial.
No, actually, if you look at the reported federal cases, including at the Supreme Court level and at the Ninth Circuit level, those cases almost always are focused on weeding out those ones that don't have sufficient evidence to get to trial.
It comes up in summary judgment all the time, but the McDonnell-Douglas scheme gets you to the ultimate result. Within the pieces of the McDonnell-Douglas scheme, of course, the federal court would have to apply its summary judgment doctrine on each prong. But I'm not sure that you can say that the entire three-part burden-shifting process needs to be established on summary judgment. The question is only whether there's an absence of a dispute of fact that prevents the plaintiff from moving forward.
That's always the question on a summary judgment motion, and that's a legal question getting a full circle around to whether or not Tom Slackett's opinion carries the day, or whether or not, when you look at this de novo and you look at the record that Judge Gordon had before him, if there's any evidence at all that was sufficient for a jury to find from this record that there was race-based discrimination instead of a legitimately proffered explanation for Mr. Aquani's termination. Any other questions?
No.
Thank you.
Counsel. Counsel?
Thank you, Your Honor. Just very briefly, 2 points. Number one, no one is suggesting that Tom Slackett's opinion carries the day. What we are saying is that under 122602, the Equianis were thrown out of court because Justice Slackett did not address causation. So Justice Slackett addressed causation in the only way possible. He said, in my opinion, if they had used this material and if they had not made these wrongful admissions, the court wouldn't have thrown the case out of court.
Okay, so let's assume for a moment that we are reviewing de novo Judge Gordon's determination that summary judgment would have been granted anyway.
Yes.
Point us, if you would, to the disputes of fact that your colleague says are lacking on the race-neutral justifications.
Gladly, and thank you for that opportunity. I didn't know we were going to get that at this hearing, and I'm glad we are. They have an affidavit from Whining Mao, a co-worker. The employer's argument was Henry Equiani needs to be fired because, among other things, he doesn't take direction and he's incompetent. Whining Mao gives an affidavit saying he takes excellent direction and he's very competent, he's the best. He's the only one with a PhD. He solves the stuff none of the rest of us can solve. They don't include it. Why? Because they wrote in an email later, oh, sorry, we didn't read this recent Ninth Circuit case that said we can include affidavits from coworkers. We thought we could only include affidavits from supervisors, and Mr. Mao's a coworker. So they didn't include it. Same point, David Suarez, coworker. Henry Equiani is an excellent employee. He's very good at taking direction. He's been a leader on the team. Oh, we didn't include it because we weren't aware of the case law that allowed us to include it. We've been on vacation, and we missed that. Next point, multiple letters, where in the initial letter they said, well, Henry, we haven't discussed this with you, but we'll discuss it now. Then they went and talked to their lawyer, and he said, no, you had to discuss this with him like 4 months ago, so it was before he started raising race. Final draft of the letter says, Henry, as you know, we've discussed this with you for the last 3 months, and now we're discussing it with you again. We got all the drafts of the letters that showed they were lying. And the first letter indicated that they had never discussed it with him. Fourth point, Statement of Fact 101. The whole case against Henry Equiani is he's mocking, he doesn't take direction, blah, blah, blah. In the email, a guy who really dislikes Henry Equiani and is very critical of him says, I got to give Henry this. When we criticized his presentation, he took the direction very well, perhaps too well. He took it excellent. That's what it says in the email. They come out in their motion and tell Judge Martone, this email establishes that Henry Equiani can't take direction. And they admit it. They say, admit. And don't dispute it, and don't show the actual email, which says the exact opposite. The HR head is deposed. She says, yeah, we have about 50 employees in this division. How many are black? Usually 1 or 2, and that's been steady across time, yes. And how many people have you ever put on a permanent warning and then fired in the whole history of the division? 3. And were all of those 3 black males? Yes. Oh, and we did put one lady on a warning as well, and she was a white lady. Did you fire her? No. So the only people they've ever put on warnings and fired were black people who make up about 2% of the division, 3 of them. One of those 3, they try to get in touch with Cornell West. He says, sure, I'd be happy to cooperate with you. They admit that. Then they blow it off. Months go by and he disappears. So for Judge Gordon to say, yeah, I'm not even going to make a record on this. I'm just going to ignore Justice Lackett's opinion after throwing them out of court because he didn't offer it previously under 122602, and I'm going to find as a matter of law that they didn't meet the standard. That was just wrong on the record. And with that, my time is concluded, and I'll conclude, Your Honor, unless you have any questions.
No, thank you, counsel. We'll take this matter under advisement. We'll issue a decision in due course. Court's in recess.